Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Welcome to the Deep Dive, where we cut through the noise to get to the heart of what truly matters. Today, we're plunging into a pivotal legal showdown that ripples through our farms, our dinner tables, and, well, the very future of agricultural innovation.
We certainly are. We're dissecting a landmark Indian Supreme Court case, Monsanto Technology LLC versus Nuziveedu Seeds Ltd. And really, it's more than just a patent dispute.
Right.
It's a deep dive into the delicate balance between intellectual property, plant variety rights, and, crucially, the integrity of the judicial process itself.
Our mission for you today is to decode this, let's face it, technically complex dispute. We'll trace its journey through the courts, understand the core arguments from both sides, and really uncover what the Supreme Court's decision truly means.
And not just for these companies, right?
Yeah.
But for the entire landscape of innovation and agriculture.
Exactly. We've gathered the essential nuggets from our research, including all notes 19D62062 and 25 and Monsanto SC case.pdf to give you a real shortcut to being well-informed. So let's begin.
Sounds good.
Okay, to set the stage, let's first introduce the key players and, what ultimately landed them in court.
Right. So on one side, we have Monsanto Technology LLC. They were the plaintiffs, the appellants in this Supreme Court case. They're a technology company holding a specific patent, number 2144436.
Okay.
This patent relates to their Bollgard and Bollgard 2 brand cotton technology. What's really central here is their patented nucleic acid sequence, or NAS.
NAS.
Yeah, think of it as a man-made DNA blueprint. It's specifically designed to make cotton plants naturally resistant to certain insects.
Got it. And their opponent, who are they up against?
That would be Nuziveedu Seeds Ltd., an Indian seed company. They were the defendants, the respondents. Now, their relationship actually began back in February 2004.
Okay, quite a while ago then.
Yes, with a sub-license agreement. This basically allowed Nuziveedu to use Monsanto's technology, that NAS, to develop and sell genetically modified hybrid cotton seeds.
And in return?
In return, Nuziveedu paid Monsanto a license fee, which is often called a trait value.
So, a fairly straightforward business arrangement, it sounds like. What caused it to unravel?
Well, the relationship started to sour over disagreements about these license fee payments.
Yeah.
It got particularly tricky after a new state-imposed price control regime came into effect, which limited what could be charged.
Government regulation changing the dynamics.
Precisely. And this dispute led Monsanto to terminate the sublicense agreement in November 2015.
Okay, so termination. Let's unpack the legal journey that followed, because I think the path this case took through the different courts really reveals the core insights of the final Supreme Court ruling.
Indeed. The timeline is critical here.
Yeah.
So shortly after that termination in 2016, Monsanto initiated a civil suit.
Right.
They sought a permanent injunction to stop Nuziveedu from using their Bollgard and Bollgard 2 technology, alleging patent infringement, and they also asked for a temporary injunction while the suit was ongoing.
And Nuziveedu's response?
Well, Nuziveedu fought back. They claimed their rights were protected under India's Protection of Plant Varieties and Farmers' Rights Act, 2001. We can call it the PPVFR Act for short.
PPVFR Act. Got it.
And crucially, they also filed a counterclaim. They asked the court to revoke Monsanto's patent altogether.
Revoke it? On what grounds?
They argued it was invalid, specifically under Section 3J of the Patents Act. Now, this section generally excludes plants and seeds containing DNA sequences from being patented. It's a key point of contention.
Okay, so patentability itself was challenged. This brings us to the first judicial decision then. How did the initial court handle such a complex dispute?
So on March 28, 2017, the High Court's single judge, think of this as the main trial court level, heard Monsanto's application for that temporary injunction.
Okay.
And the judge, quite insightfully actually, recognized the deep complexities, especially around the scope of the patent claim. They concluded these issues would require, and this is a direct quote, formal proof and expert opinion, meaning it needed a full trial with evidence and expert testimony, not just a quick decision at this early injunction stage. So the single judge did not rule on Nuziveedu's counterclaim to revoke the patent then.
Just parked it for later.
Essentially, yes. Acknowledged it, but deferred judgment. Importantly, though, the judge ordered that, pending the full trial, both parties had to stick to the original sublicense agreement terms, but with the fees adjusted according to those new state price controls.
Interesting.
Yeah, and the court even noted that Monsanto's termination of the agreement appeared unjustified because of those statutory price restrictions.
So the single judge basically said, look, this is too intricate for a snap judgment. Let's have a proper trial to sort out these technical details.
Yeah.
But that wasn't the end of it, was it?
Oh, not at all. This is where the plot, you could say, truly thickens. On April 11, 2018, a division bench of the High Court, that's a higher appellate court, with multiple judges heard appeals from both Monsanto and Nuziveedu.
Both appealed, okay.
Yes. And this bench, well, it dismissed Monsanto's appeal. But more significantly, it sided with Nuziveedu's argument about patent exclusion under Section 3J of the Patents Act.
The part about plants and seeds not being patentable?
Exactly. They stated that Monsanto should have sought registration under that other act, the PPVFR Act, implying a critical distinction. That these two laws, the Patents Act and the PPVFR Act, are exclusive for these kinds of cases. You fit under one or the other, not both.
Mutually exclusive.
Right. And consequently, the division bench then allowed Nuziveedu's counterclaim and effectively revoked Monsanto's patent, just like that.
Wow. So Monsanto's civil suit could only continue for damages claims, not for the actual patent infringement.
That's right. The core patent infringement claim was essentially knocked out because the patent itself was deemed invalid by the division bench.
So wait, the division bench jumped in and decided the patent's validity, this incredibly complex technical issue, without the full trial the single judge thought was absolutely necessary. That sounds quite extraordinary.
Precisely. And that action, that summary decision, became the absolute central issue when the case reached the final stage. The Supreme Court, India's highest court.
Okay, so the final act.
Yes. On January 8, 2019, the Supreme Court, specifically Justices R.F. Nariman and Nevin Sinha, delivered its judgment. And they found that the division bench had, and this is their word, usurped the single judge's proper authority by summarily deciding that counterclaim.
Usurped jurisdiction. Strong language.
Very. They emphasized that a summary adjudication of a technically complex suit requiring expert evidence like this one is simply neither desirable nor permissible.
So procedure matters a lot.
Immensely. And the ultimate outcome from the Supreme Court.
What did they decide?
They decisively set aside the division bench's order, completely wiped it away. They restored the single judge's original order from March 2017.
The one that kept the license agreement going and called for a full trial.
That's the one. Maintained the sublicense obligations, kept the interim injunction in place, and crucially, sent the entire suit back down to the single judge for a comprehensive full trial according to law.
Back to square one in a way, but with a clear instruction.
Exactly. And they stressed the need for cooperation from both sides to get it resolved quickly, given the, vital national importance of the questions involved.
So this Supreme Court decision, it really prioritized the proper legal process over a quick, perhaps premature decision on these highly technical matters. Why should this specific aspect matter to you, the listener?
Well, because this wasn't really about who won the patent dispute itself at that point.
Right.
The Supreme Court didn't rule on the patent's validity.
Right.
Instead, it was a powerful statement about how justice must be delivered, especially in intricate, specialized cases involving complex science and law. It sets a huge precedent for India's legal system.
Okay, now that we have the full timeline and the procedural core of the Supreme Court's ruling, let's unpack the specific arguments. What was Monsanto really arguing to defend their patent?
Well, Monsanto staunchly argued for both the validity and the infringement of their patent, number 214436. They really emphasized that their patented nucleic acid sequence, the NAS, was, in their words, a man-made DNA construct.
Meaning it didn't exist in nature.
Exactly. They were clear. This NAS wasn't a living organism itself, but a chemical structure created in a lab. And only once this structure was inserted into a cotton plant did it make the plant insect tolerant.
So their core claim sounds like this is a unique artificial creation, a chemical invention, distinct from a natural plant, and therefore patentable under the Patents Act.
Precisely. They further contended that their invention was fundamentally different from anything covered by that other law, the PPVFR Act.
How so?
They asserted that a chemical gene, a DNA construct like their NAS, simply isn't a plant variety, as defined by the PPVFR Act, so it couldn't even be registered under it. From their viewpoint, the Patents Act and the PPVFR Act operated in, separate spheres for this type of technology, mutually exclusive.
Okay. And how did Monsanto react to the division bench just revoking their patent without that full trial?
Oh, they reacted strongly. Their legal team, which included prominent lawyers like Dr. Abhishek Manu Singhvi, argued vigorously that the division bench had committed a clear procedural foul, basically.
A procedural impropriety.
Yes. They hammered the point that the single judge had correctly identified the need for formal proof and expert evidence to sort out these complex issues like patent validity and whether Section 3J even applied.
Section 3J being the exclusion for plants and seeds.
Right. Monsanto maintained they never consented to having their patent just wiped out summarily like that. Any consent they might have hinted at was only about deciding the patent's scope for the temporary injunction, not for killing the patent entirely. They basically said it was unthinkable they'd agreed to a summary invalidation of a valid registered patent.
Makes sense from their perspective. Now, shifting gears, what were Nuziveedu's counterarguments? How did they defend against Monsanto's claims?
Nuziveedu had several key lines of defense. First and foremost, they attacked the patent's validity head-on, using that Section 3J of the Patents Act.
The exclusion clause again.
Exactly. They argued that once Monsanto's NAS was put into a plant, it became, and this is important, an inseparable and inheritable part of that plant. It happens through a natural biological process, exists in every single plant cell, and gets passed down generation after generation.
So not like a separate chemical component anymore.
That was their argument. They claimed it wasn't a product you could just sell in a vial separate from the plant, making it unpatentable under 3J. They even argued there wasn't really an inventive step until the NAS was in the plant, and at that point, the Section 3J exclusion kicks in.
So they framed it as fundamentally a biological outcome, inseparable from the plant, rather than a distinct patentable chemical product.
Precisely. That was a core part of their case. Their second main argument relied on the PPVFR Act, the plant variety law.
Right, the other piece of legislation.
Nuziveedu contended that if Monsanto's patent rights were fully upheld, it would essentially undermine the entire purpose of the PPVFR Act.
Why?
Because that act was specifically designed, they argued, for protecting plant-related intellectual property and, very importantly, farmers' rights. They framed Monsanto's claim as being like that of a breeder creating a new plant variety.
So Monsanto should have used the PPVFR Act.
That was Nuziveedu's suggestion. They argued Monsanto's original donor seed, the one with the NAS, should have been registered under the PPVFR Act. This would entitle Monsanto to benefit sharing under Section 26 of that act, but not full patent control.
Benefit sharing, not a patent monopoly.
Right, and they heavily emphasized farmers' rights under Section 39 of the PPVFR Act. This section broadly allows farmers to save, use, sow, and resow seeds from their harvest, even from registered varieties, a critical right in Indian agriculture.
Okay, so two main pillars. Patent invalid under 3J, and alternatively, this should fall under the PPVFR Act. What about the infringement claim itself? Did Nuziveedu just admit to using the tech?
No, they emphatically denied direct infringement of the patent as claimed. They explained their process.
Which was?
They said they would sow their own cotton varieties next to Monsanto's transgenic bee cottonseed, then cross-pollinate them. The resulting cotton fruits yielded seeds with a new, hybrid variety that was their own proprietary creation.
So crossbreeding, not directly making or using the NAS itself.
That was their claim. They argue they didn't use the NAS in isolation, nor did they use Monsanto's specific patented method of inserting the NAS into a plant. They received donor seeds from Monsanto that already had the NAS integrated. Their process was biological crossbreeding, they said, and therefore didn't infringe the specific claims of Monsanto's patent.
That's a subtle but important distinction they're drawing. Now, it's quite interesting. Wasn't it mentioned that even Nuziveedu, the defendants, had initially argued that these issues were too complex for a quick decision?
Yes, that's a critical point the Supreme Court itself highlighted. In earlier stages, Nuziveedu had also contended that the questions of patent validity and revocation required evidence and adjudication only at the final trial of the suit.
So they also initially wanted a full trial for these complex bits.
It seems so, based on the Supreme Court's recounting. This fact really just underscores the Supreme Court's ultimate reasoning about procedural integrity and why the division bench's summary decision was seen as inappropriate.
Okay, let's circle back to the Supreme Court then. They step in, see this procedural mess. What was their core reasoning for overturning that division bench decision? This is where the real precedent gets set, right?
Absolutely. The Supreme Court's reasoning was fundamentally about how complex legal disputes, especially technical ones, must be handled. It was deeply rooted in legal procedure.
So, point one.
Point one, they reiterated, almost like a fundamental principle, that summary adjudication of a technically complex suit requiring expert evidence, particularly at an early interim injunction stage, is neither desirable nor permissible. Full stop.
No shortcuts for complex cases.
Exactly. They found the division bench's decision to just revoke Monsanto's patent without a full trial, without hearing expert evidence, to be deeply flawed.
And they didn't just state this as opinion, they backed it up legally.
Oh, absolutely. The court explicitly referenced Section 64 of the Patents Act, the section dealing with patent revocation. They stated that invoking Section 64, quote, necessarily presupposes a valid consideration of the claims in the suit and the counterclaim in accordance with law.
Meaning
You can't just revoke a patent based on summary adjudication sans evidence by abstract consideration based on textbooks only. You need the proper legal process.
And that process is laid out where?
In the Civil Procedure Code, the CPC, the Supreme Court strongly reinforced the CPC's mandates. Think of it as the rulebook for civil court cases. They emphasized its detailed procedure, which includes crucial steps like formally framing the issues, examining and cross-examining witnesses, discovery where evidence is exchanged, and finally a full hearing leading to a proper judgment or decree.
No skipping steps.
None. They even cited a previous case, Alka Gupta v. Narendra Kumar Gupta, to drive the point home, stressing from that case. There are no shortcuts in the trial of suits.
So the message seems crystal clear. The division bench took a shortcut it shouldn't have.
Precisely. The Supreme Court concluded the division bench ought to have confined itself to examination of the validity of the order of interim injunction granted by the single judge only.
Yeah.
That was its job on appeal at that stage.
Not to decide the whole case.
Right. By diving into the patent revocation counterclaim and deciding it summarily, the division bench usurped the jurisdiction of the single judge. The Supreme Court essentially validated the single judge's initial caution, concluding their interim order was appropriate because it correctly thought that the issues needed that formal proof and expert opinion only possible in a full trial.
Okay, so the ruling itself is clear. What does this mean going forward? For future cases, especially in biotech, pharma, other complex fields, what's the lasting impact, the precedential value here?
Well, it carries really significant legal weight, particularly, as you say, in patent litigation involving complex science and technology. It establishes a very strong precedent against summary adjudication, against quick decisions in these kinds of disputes.
So lower courts are now clearly told, don't rush these things.
Exactly. It makes it unequivocally clear that complex issues like patent validity, infringement, especially when they involve chemical, biochemical, or biotech processes, absolutely require robust evidence, expert testimony, presented and tested at a full trial.
It also seems like a strong reinforcement of just the basic rules of court procedure, doesn't it? Due process matters.
Yes, absolutely. It's a powerful reminder about the importance of the Civil Procedure Code, underscoring that procedural integrity isn't just a technicality. It's paramount for justice in civil suits.
And for appeals courts.
It clarifies their role regarding interim orders. Appellate courts reviewing temporary injunctions shouldn't jump the gun and decide the entire case on its merits before the trial court has had a chance to do its job thoroughly. And finally, it implicitly affirms the vital role of the trial court, the single judge here in patent cases. They have the power to grant temporary relief, like an injunction, to maintain the status quo, while properly reserving the final, complex determination for a full, evidence-based trial.
And this was a unanimous decision, right?
Yes, delivered by Justice Navin Singha for the bench. That unanimity further solidifies its standing as a really critical procedural landmark in Indian law.
So, wrapping this up, what does this all mean for you, listening? The Supreme Court, crucially, didn't declare Monsanto's patent valid or invalid. It didn't definitively resolve that underlying conflict between the Patents Act and the PPVFR Act either.
No, it left those substantive questions for the trial court to decide after hearing all the evidence.
Right. Instead, it sent a powerful, crystal-clear message about how these complex, critical questions must be resolved through a thorough, evidence-based legal process. No judicial shortcuts allowed, especially when the stakes are so high.
And this deep dive really highlights that, particularly in areas where cutting-edge technology like genetic modification meets fundamental societal needs like food production, the legal framework has to ensure due process. It must allow for expert consideration.
Mm-hmm.
It's a powerful reminder, I think, that sometimes the most profound legal insights aren't about who wins or loses the ultimate fight, but about how the game is played, ensuring fairness, thoroughness, and the right procedure every step of the way.
That definitely leaves us with something to think about. It raises an important question, maybe for you to ponder. What stands out to you about this balance? The balance between promoting technological innovation, often through patents, and protecting the rights and established practices of farmers, especially now as we grapple with global challenges like food security and climate change.
Yeah, how can legal systems best navigate these complex, often competing interests? It's not an easy question.
Not at all.
Well, thank you for joining us for this deep dive into Monsanto versus Nuziveedu. We hope you feel much more informed now and ready to think about these significant implications.